Major revelations in XRP lawsuit. Ripple XRP versus SEC. What you should know about the ongoing lawsuit. Ripple XRP versus SEC. Who will win the ongoing legal battle? The table of lawsuit will turn to which one? December 2020, the Securities and Exchange Commission dropped a bomb on the cryptocurrency industry by filing a lawsuit against Ripple and two of its top executives. Was that shocking? Yes, definitely was. But the game didn't end there. The U.S. Securities and Exchange Commission and Ripple Labs both filed motions for summary judgment, saying that the judge in charge of the case has enough information to make a decision without holding a trial. The case about what didn't happen is still going on from 2020. But now we have some major insights on what is happening behind the scenes in this lawsuit. If you want to know more about, make sure to stick around to the end. Hello and welcome to Crypto Castle, where we explain everything crypto. Today we'll talk about the concept of Bitcoin halving, why it's important for the space, and what will be the impact of Bitcoin halving on Bitcoin's price. Let's begin watching the video right away. The case, which hinges on whether or not Ripple and its executives sold unlicensed securities in the form of the XRP token, is a major threat to the company and the industry as a whole. If a judge decides that XRP is a security, Ripple will probably fall apart, and the SEC will have a strong tool to use against other blockchain projects. Ripple has refused to give in to the pressure. Instead, it's tried to go back at the SEC by putting up a strong legal defense and calling out the agency's questionable actions in public. The case has been going on for almost a year and a half, and it's about to reach a very important point. Has one side gotten the upper hand, and do we know about what might happen? Experts in securities law and look at the most important things that have happened so far can give us some ideas. SEC versus Ripple. Who has the edge so far? When a company is sued by the SEC, they usually settle instead of going to court. That's because the SEC only sues when it thinks it has a good case and because it's very expensive to go to court. Ripple, on the other hand, doesn't care about money. The company has made a lot of money from selling XRP so it can hire the best security lawyers in the country, like former SEC Chair Mary Jo White. But as some people have pointed out, even the best lawyers can't help a defendant who's clearly in the wrong. Hiring Mary Jo White doesn't mean anything. It just shows that they have a lot of money. You can hire expensive law firms, but the law is, well, the law. Crypto lawyer Stephen Pally said, doubting Ripple's chances. Still, Ripple's legal team has had some big wins in the early stages of the case. For example, they won the right to question a former SEC executive named Bill Hinman and forced the agency to give them documents that explain some of the things they talked about behind closed doors. Even though the details of the documents, such as minutes from internal SEC meetings, haven't been made public yet, they're likely to help Ripple's case that the agency's crypto policy has been arbitrary and hard to understand. The SEC could look bad if things come out about Hinman, the agency's former director of corporate finance. His behavior has already raised eyebrows because in 2018 he used a new legal test to say that Ethereum was not a security. Soon after, he left the SEC to go back to his law firm, which has ties to the Ethereum Foundation. Documents filed by the SEC in the Ripple case suggest that the agency will try to show Hinman as a rogue agent who acted on his own when it came to Ethereum. This could help refute Ripple's claims that the SEC has made decisions about which tokens are securities based on arbitrary criteria. It's not clear if this strategy will work, though, and Ripple may have gotten evidence from Hinman's deposition that could hurt the SEC's case. Ripple had less luck getting the SEC to hand over documents written by its own staff about crypto trading. The company wanted to show that the agency has been indifferent to this kind of trading for a long time. If this is true, it would have helped Ripple show that the SEC did not consider XRP and other tokens to be securities. But in this case, Magistrate Judge Sarah Netburn agreed that any such documents were private and could not be used in the case. In short, in the pretrial stage of the case, it's not clear if Ripple has found any smoking guns in the SEC's papers or if its aggressive tactics will help in any way. Peter Fox of Schoolage Peters, Rosati, and Fox said, based on the discovery decisions, it looks like Ripple defendants plan to put the SEC on trial has had mixed results. Again, of course, we don't know what information they found where they've been successful. Ripple CEO Brad Garlinghouse and co-founder Chris Larson tried to get the case against them thrown out by filing a motion to dismiss. However, Netburn did not agree with them. This means that the SEC gave enough evidence at the beginning of the case for it to move forward, that the executives are still in legal danger. We will keep fighting hard to defend this case so that the industry can get the clarity it needs to move forward and grow. Even though we would have liked Brad and Chris's cases to be over, the court has decided to make the SEC prove its claims. We're sure that all the SEC's claims will be thrown out in the end, the company's top lawyer, Stuart Aldery, said after the judge denied the motions to dismiss. The SEC also had a setback last month when Netburn refused to strike one of Ripple's main defenses, that it would be unfair to hold the company and its executives responsible since the agency hadn't made clear rules about whether tokens like XRP were securities in the first place. Some lawyers think this is the best way for the company and Garlinghouse and Larson to defend themselves. All of these procedural changes may not be that important in the bigger picture of the case. Though Preston Byrne, a longtime crypto lawyer with Anderson Kill, says that Ripple is still behind the 8 ball when it comes to the so-called Howey test, a 4-part test set by the Supreme Court in 1946 to show if something is a security. The back and forth in the Ripple case is pretty typical pre-trial talk. That doesn't say much about the case itself, Byrne said. I think Ripple's chances of success are low and haven't changed much. The SEC claims that the company sold tokens to investors on a rolling basis, like an investment contract. This is a view that is widely held by members of the American crypto bar. Even though the SEC and Ripple have fought over the rules, what is surprising is how slowly the case has moved forward. Not long after the SEC sued Ripple, Garlinghouse said that the parties would have their day in court as soon as last fall. Now it's unlikely that a final decision will be made before 2023. Now, before we move ahead to the key differences, please take a second to like this video and subscribe to our channel so that we can keep bringing more informative content to you. Your little contribution means a lot for us. What's taking so long? And is the delay significant? As the case dragged on, Garlinghouse and other Ripple executives took the unusual step of making fun of the SEC in public, saying that it made a mistake by going after the company. Whatever the reason for the delay, the stakes have only gone higher since the SEC sued in 2020. Since then, crypto regulation has moved to the top of Washington, D.C.'s policy agenda. As the industry's political power has grown, the Biden administration has turned to crypto as a key source of tax revenue. Gensler's own goals have also made more important. A former high-level SEC employee who spoke on the condition of anonymity said that Gensler decided at the start of his chairmanship to take a hard line against crypto to raise his public profile and win over progressives so he could become Treasury Secretary. When asked about Gensler's intentions or the SEC's strategy in the Ripple trial, the SEC did not answer. All this, however, has no effect on how the Ripple case will be decided in court. According to Fox, the case is likely to be settled by summary judgment, which is when a judge decides a case based on court documents instead of testimony given at trial. Based on the most recent schedules filed in the case, the judge is likely to rule on summary judgment motions in early 2023, unless Congress passes new crypto laws, which isn't likely to happen until at least the middle of 2023. The judge's decision is likely to be a turning point for the industry. If the ruling goes against the SEC, it will hurt the agency and Gensler a lot, and the price of XRP and other tokens will probably go up. If the SEC wins, on the other hand, it will be a blow to the crypto industry as a whole, and could lead to a wave of new actions by the agency. Byrne, the lawyer for Anderson Kill, pointed out that a first ruling against Ripple wouldn't be the end of the case, he said. Ripple seems willing to fight this thing and appeal it to the moon. So what are your thoughts about the Ripple XRP versus SEC? Tell us in the comments. And don't forget, like this video and share it with your friends and family. Also, if you like this video, then make sure to watch this next video on our channel. Thanks for watching. Bye.